Hello, I'm Dan Marr. I'm an attorney here in Nashua law firm of Hamblett Kerrigan. And I'm going to be talking today about how to hold your residential real estate in New Hampshire, different concerns that you should have in regards to thinking through how you handle that, particularly when you are holding it with another person. There's a new deed called transfer on death deeds. There's ways that you can hold the property as joint tenants rights survivorship, which means that the first one of you dies, the other one gets it automatically. There can be a life estate that you reserve in the property and you give other people your interest in it. You can put it into a irrevocable trust. You can have it in tenants in common or a revocable trust. We'll talk about that. So first, how you hold your property. If you hold it as a, if you're not married and you break up in a relationship with somebody that you're holding in real estate, if you actually have that person on the deed, you could be in a situation where the person contributed nothing to it. They just lived with you. They didn't even help pay any of the expenses. And they didn't come up with the down payment. You paid the mortgage, and they were there with you, and then the relationship ends. And in that situation, you might be in a fight with them over what's called a partition action, where you have to then go to court and fight with them, dispute with them as to whether or not they have an interest in the property and what interest they have. I've litigated those cases where people have not had any interest in it. It's a different situation when they're contributing somewhat, and then there's an issue of are they paying rent or the like. There's a whole host of issues. But when they haven't actually participated in the process, it's very tough for you to have to think you have to litigate to get them off the deed. So think about whether you should put them on the deed first. If you do, on any situation, you decide to go in with your eyes wide open and you're going as partners, the closing companies like joint tenants rights survivorship, they do that all the time in the deeds. You got to be careful about that. Do you really want that if you were to die, the asset goes immediately to your significant other, your other person, or do you want it to be in a situation where your half gets divvied up with your relatives? Think about that. Tenants in common is the way you can put it, and you can tell the closing company to do it that way, but joint tenants is a different issue. If you have a relationship problem and you have the deed in joint tenants, you can break that by doing a transfer of the deed. I've done that, and I can help with those situations. You can break it so you can actually transfer your property out and then transfer it back in and break the joint tenants with the right of survivorship. If you have a transfer on death, that's a new statute that just came out where you actually sign the deed, and within 60 days you have to record it. The deed that's in the registry of deeds, though, doesn't change anything for creditors. It doesn't do anything until you die, and you can actually revoke it just like you would a will. So you can put it out there, you can do it in the registry of deeds, and then you can pull it back. You can change your mind and do a revocation of it. The statute's new, and the courts haven't really interpreted it, so a lot of practitioners, including our firm, are wary of that, of going forward with the transfer on death deeds, but they are available right now. Putting something into a revocable trust is an option. It is a wonderful idea for purposes of avoiding probate, and revocable trusts also give people some opportunities to not transfer their assets to their children right on when they become the age of majority, so they can actually transfer distributions over time to help the children out. A wonderful tool. But if you do the deed into a revocable trust you do your estate planning, you transfer the property, first you have to transfer it into a revocable trust. Just signing the trust document doesn't do it, you have to actually transfer it. But make sure the deed says revocable. It says right in the deed, because there's a homestead exemption of $120,000 that if you have a revocable trust, the homestead applies to that property as long as you're living in the property. There's a bankruptcy case that came out where the bankruptcy trustee appropriately challenged and got the $120,000 into the estate instead of to that person, that debtor, because they didn't use the words revocable in their deed. You got to put it into the deed itself. So those are some very important issues. I've dealt with the transfer of death comments there, and the adverse, the joint tenants rights survivorship. Life estate is a situation where you reserve the right to a life during your life to have the property. If you don't make it clear, or you make it clear that way, just life estate. If you become incapacitated and you go into assisted living facility, still Medicaid or anybody else is still going to want you to rent out that property, because while you're still alive, you still have the rights to that property. So you want to think about what type of situation you want. And you also want to think about, do you want to take away that right of, maybe you could do a reverse mortgage if you want to stay in the property, but if you have a life estate, you have a problem, you may have a problem with that. So think about some of those issues, the limitations of that, and make sure to protect yourself first before you protect your children in regards to this estate, because those are your assets and you should be thinking about that. I'm Dan Marr at Hamblett Kerrigan at 603-883-5501, 603-883-5501. Happy to talk to you, or you can check out our website, NashuaLaw.com. That's NashuaLaw, all one word, .com. We have all these vlogs on there. My radio show that I did weekly radio show I did till March of 2023, and a lot of other useful information. So check out our website. Give me a call if you have any questions. Happy to help you. Thank you.